when Moses saw the face of God, the universe seemed to stand still. Moses stood before God for 40 days and nights, without food or water, speaking with the Creator face to face. When he came down from the mountain with the new tablets of the law, his face radiated with a supernatural light. The people, including Aaron, were afraid to look at him, as he unknowingly reflected the glory of God. From that moment on,
did you know that when God had created the world after the fall of man, God created a strategy of settling disputes or crimes by reaching a mutual resolution that is fair and just? Therefore, God gave Moses the laws on how to solve the conflicts or crimes, and these laws were to help the judges or judicial officers or people in authority in the law to find a proper mechanism of finding out the truth. Remember, crimes are committed when nobody is there. No one saw that person committing that crime. Therefore, God put also a strategy on how to solve these, to come up with the truth, to find out the truth, to inquire and find the truth. And that's what even today the law has adopted. Even the laws today have adopted the God setting. Because if you check in the Bible, in the book of Deuteronomy chapter 13 verse 14, God taught that, then shalt thou inquire and make search and ask diligently, and behold, if it be truth and the thing certain that such abomination is wrought among you. Therefore, God wanted that judicial officers must make search to make sure that the suspect is really the one who is the culprit or is responsible of the act of the crime. They had to ask diligently. So this brings us to the doctrine of presumption of innocence, where a person is presumed innocent until proven guilty, meaning there is that element of proving guilty. And also this introduced the element in the Old Testament during Mosaic law of introducing witnesses. So the judge compelled witnesses to come and testify so that the suspect can be apprehended. In the book of Deuteronomy, again, chapter 17, verse 6, the Bible says that at the mouth of 2 witnesses or 3 witnesses shall he that is worthy of death be put to death. So here we find that there had to be a witness, at least more than one witness. So in the God setting, one witness could not attract a conviction. So court could not rely on one person to make a conviction. If there had to be a witness, that testimony had to be corroborated at least with another witness. So now, when you find in our laws even today, under section 59 of the Evidence Act, cap 8, there is a strategy of determining a credible or competent witness, and this witness must give testimony that is direct, that is to say that it refers to a fact which could be seen. It must be the evidence of a witness who says that he or she saw, not someone who heard. So if it refers to a fact which could be heard, it must be the evidence of a witness who says he or she heard. Now, that witness, for him to be competent, must have seen the act or the atrocity happening, or must have heard with his or her ears that something happened, must have perceived with his mind, or must have touched and felt. That one makes a credible witness. Or an expert who goes ahead and makes examination, does experiment to determine the veracity, to determine the authenticity of the allegations. And there are very many witnesses that courts and the judicial system have employed so that they can settle such disputes that arises between people. Remember, disputes are part and parcel of our life. You are at the legal stamp, whereby you're going to learn many things. And now today we are comparing the biblical setting with conflict resolution using witnesses, and the current today legal regime, or the today's jurisprudences in various areas on how they rely on the testimony of witnesses to solve issues. And now you see some cases require special attention due to their unique needs and requirements, because now there are some matters which are done at night, or which are done when it is nighttime, it is dark, nobody's there, nobody's seeing. Or during day, you may find that the old person is not there, and you might find that it is a young child who is there, or someone who is dumb, or someone who is deaf, or someone who is blind, is the one who saw and witnessed that atrocity being happened. So those are witnesses that court can use to determine the truth of the allegation. And also it is important to know that there are various types of witnesses that courts of judicature relies on to summon and so that they can come and testify whether or not the suspect committed the crime or is responsible for the action or for the breach and confusion. Now we have expert witnesses, we have hostile witnesses. Now a hostile witness, this is a witness that comes to court to testify in a legal proceeding to a certain party, but upon reaching court, his testimony end up being unfavorable or even antagonistic to that party's case. Meaning you call that witness to testify in your favor, but it ends up testifying against you. So that is one of the witness that happens. So court must focus on the chain of his evidence and testimony, right from the police even to date, because people are there. We also have refractory witnesses. These are witnesses. A refractory witness is a witness who, after being properly summoned and required to appear in court, refuses to attend or refuses to testify. He runs away, he hides himself, say, I will not go in those proceedings. I'm no longer interested in testifying in that matter. Or when he reaches, let's say, in the witness box in court, required to testify, either he refuses to testify, he backs out, he's not interested, he loses all the focus. So those are witnesses that require special needs, because judicial officers are trained and skilled personnel. They know how to handle those witnesses. On speaking of refractory witnesses, we also have witnesses that require a viodia. These are children. Remember, a child of tender age or a child below the age of 18, sometimes they lack some intellect, they lack some a lot of wisdom and knowledge and critique and let's say logic to understand and interpret things. So for them, they need special attention. They have, if he's a little child, let's say 6 years, 7 years, or 8 or 10, or even 11, they have to go a state court. They have to go in viodia. They have to court has to conduct a viodia, asking them simple questions to determine whether they are credible, whether they understand between the difference of telling the truth and telling lies, so that they can ascertain whether or not the testimony of the child can be a major witness to in resolving a matter. So there are very, very many witnesses. Now, speaking of such witnesses, a credible witness we need to know are expert witnesses. As I had earlier mentioned, that expert witnesses are very crucial. They did not witness with their eyes the act being performed, but an expert comes in to interpret complex situations, difficult situations where you and I, ordinary people, cannot interpret whether or not that crime was committed by a particular suspect who is in the dock. So now, such an expert witness comes in with that knowledge that he studied with, that special training. E.g., it could be in complex financial data. Remember, you and I, we may not be well acquainted with financial information. So an expert can come to interpret complex financial data and also may predict the future. E.g., like an economist projecting expected life earnings of a particular enterprise. Now, when we go to criminal matters, you will find that an expert or a matter will require an expert to come and give a testimony. For example, in accident investigation, when you're trying to establish negligence in accidents, also in ballistics, those ammunitions, weapons of mass destructions, even guns and pistols. In those ballistics, you need an expert to come and do gunpowder, to come and do fingerprints, to come and test which bullet, which gun released such kind of bullet, such that you may know that these bullets or these guns came from a certain barracks or from a certain group of people. Therefore, those must be the prime suspects. So that's why experts are very necessary in ballistics. We also have blood tests. Now here in the blood test, you need an expert to determine the DNA, deoxyribonucleic acid. Many people do not know DNA in full. So we need such forensic experts to come and carry out a DNA test in blood samples. We also have breath tests. We have people who drink alcohol or who abuse drugs, go and commit crimes. Therefore, you need an expert to come and test the breath of that person. It could, whether there was blood alcohol levels in that person's veins. We also have facial mappings. We have people who read the experts who know to distinguish faces, who can study the eyes, who can come up with various experiments on someone's to come and connect that facial mapping. We also have fingerprint identification. We have those experts that take fingerprints, interpret them, and establish that it is indeed so and so who participated in the commission of this crime. We also have voice identification. You need an expert to determine, to differentiate different voices, whether this voice was for the other person, because people can be mistaken. Laymen can be mistaken of what kind of voice, what kind of voice the suspect speaks or the suspect produces. So you and I, we may not be in position to know the kind of voice. Therefore, you need an expert to come in there and remedy that. We also need handwriting experts. If one of the parties or the suspect is denying to have signed particular documents, to have signed them, therefore you invoke a handwriting expert to come and establish that indeed that man is just making mere denials, is the one who signed on those documents. We need medical experts, scientific experts. We also need architecture experts, engineering and technological issues, market value experts, trade practice experts. We need foreign law experts. Very many. Without an expert, it is impossible to prove a matter. God also says that prove your matter. In the mouth of 3 or 2 witnesses shall every word be established. This is how God naturally created conflicts to be resolved, through witnesses. Don't think it's just a new phenomenon that has come in. No, it has always been there. It is very good. If you have the matter, you find credible witnesses, people who know, not people who had. For me, I had someone who saw. Because if a matter like a criminal matter comes up and the prosecution does not have witnesses, and the matter maybe is adjourned once, twice, even thrice, and the prosecution, they are not showing signs of producing witnesses, adducing more witnesses, or even one, the matter can be dismissed. We've seen so many matters being dismissed because prosecution has failed to adduce witnesses. So that is what we wanted to show. We made a comparative study between the legal setting and the biblical setting, God and man. So men whom have made these laws go and take from the word of God and learn what is the right way of resolving conflicts using witnesses. Therefore, stay tuned at the legal stamp so that you may know such important things, such creative connections that you may need to know, and be knowledgeable in the law, be knowledgeable in the areas of life, because everything is run by the law.